Hi, I'm attorney Josh Jones, and I'm a criminal lawyer here in the state of Michigan, where I maintain a criminal defense law firm and where I specialize in medical marijuana defense. And in today's criminal law video series, I wanted to discuss this idea of medical marijuana compliance checks, or just the idea of what a medical marijuana patient or card holder should do when an officer comes to their home and they're wanting to ensure that they're within compliance of the Medical Marijuana Act. It's important to first remember that as a card holder and possessing your card at the time while you're engaging in medical use of marijuana, you'll be presumed to be at least legal or acting within the confines of the Act. And what I mean by that is, say you're at your home, officer approaches and opens the door and says that they believe that there's some sort of marijuana activity going on at the home. Your first comments or reply should be, I am a valid medical marijuana card holder, here's my card, and that I'm in compliance with the Act, at least if you are. Now, if you're not, you should just refrain from going any further than establishing that you have your card. But the whole idea is that without more facts other than marijuana use or marijuana activity, presenting the card creates this presumption of legality under the Act. Because you as a card holder, for example, as a patient, you could potentially cultivate and possess marijuana. So if an officer comes to your door and you're a patient and believes that you may be growing in your home, growing in your home technically isn't illegal as long as you're within your 12 plant limit and you have your card. So when the officer approaches without knowing how many plants you have in your home or how much weight you have on you or within your home, having that card at least substantiates the smell of marijuana and thus then creates the presumption of innocence at that time. Now the officer can investigate more and attempt to rebut that presumption. And by investigate, I mean question, or try to come in and search your home in order to ensure that you have your correct number of plants or that you have the correct amount of weight. So under my hypothetical, the officer approaches the patient's home, the patient identifies himself as a card holder, and you would think that the conversation would cease to exist, or cease to continue, rather. But the officer then asks the patient, can I come in and search to make sure that you're within the Act or within your numbers? And at that time, the patient has two options. One, yes. Two, no. My advice is always to say no. And you never know what the officer may or may not find, or at least may or may not see to establish criminality. Because again, not everyone's a lawyer, and we understand that, which is why I make these videos, so that you are being reaffirmed that you have the absolute right to tell the officer, no, you can't come in. Unless you have a warrant, no, you cannot come in and check my grow. And I see so many individuals allow for the opposite to happen, allow the officer to come in and check something, and then they find out that, oh, that individual is not in compliance, and now they're looking at a 4-year felony. So this is why I harp on the issue so vastly, that you tell the officer no, force them to investigate, force them to rebut that presumption of innocence that you've automatically established, at least based upon the facts of my hypothetical. So that kind of brings me back around these compliance checks in these areas. It's informative to say that as of today, March 28, 2017, I'm not aware of any state law requiring a simple patient or caregiver to be forced to allow an officer to have a compliance check within their home. Now, when we're talking about the Licensing Facility Act, which brings about a whole array of different licenses for possible growers, dispensaries, and what have you, those individuals will be subject to compliance checks. But that act is separate, or that legislative that legislative language is separate from the original traditional Medical Marijuana Act establishing just your traditional patient and caregivers. And it's not taking away from that act at all. So that's why I say it's important to have this video and to make sure that individual patients and caregivers know that you, as just a patient and caregiver, do not fall under the Licensing Act, meaning you're not required to provide any individual officer with a compliance check at your home, as far as I'm aware. I do understand that there's some local ordinances trying to be passed, forcing the hand and allowing officers to do these compliance checks. And I would simply tell you at this time, until there's a higher court articulating their opinion on this issue, is to stand your ground and maintain your constitutional rights as they've been laid out in this video and other writings and videos on the internet, where you have the right to be free from unreasonable search and seizure unless there's a warrant. And even then, the constitutional right of unreasonableness stands in order for you to fight and determine if that warrant is valid. So medical marijuana patients and caregivers don't sit down, don't lay down for officers. Stand up, and especially when you're in your home and they're trying to force their way in to see, are you legal? If they want to do that, then that's fine. Just make them go get a valid warrant, and then they can come back and do all the searching they want, because they'll have done and performed a valid investigation, which you can't really harp on them for doing. Now, if it's invalid or illegal, then we have a different story for a different day. But hopefully you found this video informational and educational, and I look forward to providing more in the future. Have a great day, everyone. Bye.